Going back to the pro rata payments, in the notes we have, it shows a really steep increase.
Yes.
From 13-14, 1.8 million to 16-17, 5.2 million. Can you give an explanation, either one of you, of what that increase is about, and then maybe can we delve a little deeper into why it's so high?
So as the commissioner stated, as we implemented GRP2, the transition of bringing the then department to under the structure of as a bureau under the Department of Consumer Affairs, many things were taking into account. Staffing, technology, as the commissioner stated. So we did a full assessment, and in that we made the arrangement to have a substantially less pro rata during that transition period, and after transition, the formula that is being used now is consistent with other bureaus and boards of similar size. So in essence, the Bureau of Real Estate is paying comparable to what others of the staffing size would be paying.
I understand that, but in the notes I have, it does say the Bureau, which may be a difference from some similar size bureaus, has a lot of in-house services, including its own IT system, e-licensing, their own legal counsel, and their own call service. So is it just based on the size of their population or on the true use of DCA's resources?
There's many formulas. True use is one formula that's used to calculate pro rata. 2-year forward is another. Allocated positions is another. And notwithstanding the fact that, as the commissioner said, they do have their own hubs. They have a very seasoned legal staff, information technology staff, et cetera. The department requires staff to provide that backbone of support and oversight. So they are very independent and do a lot of good work. But there are times that we do provide oversight. With that, that's where a certain formula that I spoke to earlier comes in, and there are still overall costs of providing that oversight.
I mean, I understand that rationale. I guess it's. I'm not sure how we kind of dig into this, to find out, because the 5 million. So you're saying similar sized bureaus are all charged about 5 million for the pro rata. And then I guess the only way they could save money is to shift more services onto DCA. They could actually maybe, stop what they're doing and have DCA do the call center or something like that.
Seems like they're doing more than, if you don't mind me just piling on here a little bit, but it seems like that the Bureau is doing more than maybe other bureaus are doing, and therefore shouldn't be paying the same amount as some of those other bureaus because they're not relying on DCA for a lot of those services. And from what I heard, some of those services aren't quite as good as or responsive as when they were doing them on their own.
Well, to take the first question first, we constantly look at ways of readjusting pro rata, multiple times a year, et cetera. There are certain costs that cannot be diminished because it could detrimentally affect other clients within DCA. We do take into account through certain formulas what services are being subscribed for. So all of those factors are being taken into account. The latter question with regard to the services provided, as Mr. Bell stated, diminished services or inadequate services, Mr. Bell has called me and if there is any problems with services, my Chief Deputy Tracy Ryan and I quickly get on it and address that issue.
If I may,
Of course.
through the chair. When you were, and I don't know, Mr. Bill, if you can answer this question, but when you were your own department, have you, and a lot of times we were like, we want efficiency, we're going to put departments all together, and we're going to gain efficiency, and we're going to save money by doing that. In your estimation, I mean, has there been a cost savings with this transition, or is it this roughly the same cost in terms of overhead, administrative functions, or has it increased?
Our assessment is the costs have increased, and
Have increased?
they have
Okay,
increased.
that wouldn't
yes.
be what we would be trying to get to, I don't think, when we're, trying to do a consolidation.
And let me, if I can, just kind of paint what we had when we were a department. And we are sort of a square peg
Right.
in a round hole
Well,
now.
and to be clear, this was something, DCA didn't really ask for. This was a reorganization that occurred a few years ago, and I think we just want to see if it was an effective reorganization.
And I also understand the reorganization was looking at cutting down the number of entities and putting like entities with other like entities.
Right.
So cost was
But-
not the only issue. I
But let's
know.
talk about the cost.
Okay. I can tell you that we continue to have a robust IT unit. They developed an EIS system back in 1996, some 20 years ago, and we have an e-licensing system. We have a group of lawyers on site in our main office in our law office in Los Angeles, as well as our Sacramento headquarters. We have about 17 administrative prosecutors. We have an audits unit. We have an enforcement unit. We do our own correspondence. It's reviewed by DCA's correspondence unit. We put together our own publications. They edit our publications. They refine them for public consumption. And we do what we've always done. We sort of moved in a box in many ways. And the difference is we receive certain services from DCA that we used to do ourselves. We did fiscal work ourselves. We did contracting. We did our own supplies. We reimbursed our employees, and that's now done by the Department of Consumer Affairs. And with the pro rata at the amount it is not a cost savings.
What do we do about that?
I don't know. I mean, it just shows that maybe it should go back to be a department.
And there is legislation. Thank you for the follow-up.
Well, that's my pleasure.
Could you comment on pending legislation AB 1545 by Irwin that would create a state of California housing agency and would transfer you back to an independent department?
The only thing I can say is I'm an advocate of housing, low-income housing generally, so that we can bring the cost down throughout the state. With regard to the structure of the entity that I oversee, I can just say that in some ways I'm like a field commander, and I just am given whatever personnel I have, whatever infrastructure, whatever equipment, and I perform the job that I have been given under the statutes. And we're doing that under the Department of Consumer Affairs. So I can't comment on AB 1545, nor on the recreation of the Bureau as a department.
And I do understand that. However, I think we've done a little good work here today on behalf of Assemblymember Irwin's
Irwin,
effort
yes,
with this
we did.
bill, because I hope that one of the things that will be considered as the bill's going through the process is the whether or not there was cost savings, with the original move, and whether it would actually be achieved. And as you said, that's not the only thing. We all know we can save money by providing less service. The real question is, is the same level of service actually now costing more?
Yes.
And as an independent department, can we return it to something that's maybe more effective? So thank you very much. And it is a unique, not a normal bureau, not formed as a bureau, and that's normally what's in DCA and they are very dependent, and that's the whole nature of it. And so we understand, I'm not being, I think the questions here are coming from a place of understanding this is a unique situation, not that there's something amiss with DCA, but that we have something that may not be fitting, our square peg may not be fitting the way it needs to at this point in time.
Yeah,
Thank you.
Very good. No, thank you, Madam Chair. Thanks for bringing that up and addressing that issue, because I think that it's critical when we look at the makeup and the positioning of real estate and how it's dealt with. A couple of questions just to follow up on public outreach. You were very clear on how you're engaging with the community and trying to educate the community and working with them. And you did mention briefly how it works the other way, where the community has been able to engage you in certain issues that may be related to concerns that they may have. And has that worked both ways, I guess, is the question.
It has worked both ways, Senator. In fact, whenever I go out and speak in the public, I make certain that I ask everyone who's there to please have a dialogue with us. And part of the dialogue would be how we can be better at what we do, what we can do differently, how we can help enhance consumer protection. And I've got my executive team behind me. They know that that's what I do when I'm out, and I know that's what our folks who go out and speak do as well. Because we're here as public servants and we want to have the best possible result as far as protecting the public in connection with real estate matters. And so the question always is, are we doing enough? How can we do things differently? Is there some things we should eliminate? Are there things we should add? And so that is part of the dialogue, part of the discussion. And it's always something that is put out whenever we meet in public forums.
Do you ever hear from the public about the $11 million loan that they that was?
I have never gotten that question from a member of the public.
Oh, okay, but is there any issue related to that? I mean, that if you could get the $11 million back, that would be a wonderful opportunity to provide the resources.
As you know, many years ago, prior administration borrowed money from a number of special fund agencies. We have that on our books as a receivable. It is earning interest. And I do believe, I'm not certain, but I do believe it is scheduled to be paid in, I think, 2 years.
Oh, that's good. But we do have the money now,
yes.
So it should be paid off. Did you have a comment?
No, I just wanted to echo what the commissioner said. This is something, a lot of credit to the Department of Finance and my budget shop. This is something that they're taking very seriously, and they're going through each one of the boards and bureaus to look at the fund condition, look at the loan repayment, and schedule those, when it's appropriate.
Good.
So I want to echo what he said.
Very good thing.
What's the interest rate?
Frightening that I actually know this. I believe it is little less than 1%.
We need to get our student loans into this program.
I could not
for,
agree more.
California students.
Yeah, that's very true. Mr. Bell, in terms of the license suspension,
yes.
in how many instances approximately does the Bureau believe it cannot suspend a license because of that provision in BPC Code 10177? Does it present a problem to you?
It is the language which follows the language I quoted,
Yes.
which says, and after the time has elapsed for appeal, that poses the issue for us. And what we have in a number of cases are our licensees who will plead guilty in court. It's a knowing waiver of their rights. They say, I'm guilty of whatever crime it happens to be, and many times they're felonies. And in each case, they're substantially related crimes. And we can't use those until there is a conviction entered by the judge, until there's a sentence, and until the time for appeal is run. And the view that I've heard advanced is, if someone enters a knowing plea, perhaps maybe we should have the ability to suspend a license at that point, and if they withdraw the plea, they can have their license back. But that's for these committees to determine based on the rights of the accused as well.
Okay. Very good. That's very important to hear. The other, just final question, consumer recovery account.
Yes.
On that issue, and you talked of it, and it seems that there are, as I read the report, more demands on that account
Yes.
in the next few years, and you feel that it's that it is sustainable as it is, or should it, the sweeping of it seemed to be a problem that I could see, and the amount there will not be adequate to meet the needs. That's the first part of it. And then the second is just, it appears that this is kind of a pseudo-insurance policy, for errors and omissions insurance. Has there ever been a requirement or thought of having a requirement for that? And
I'm not aware of let me start with your last question.
Yes.
I'm not aware that there's ever been a requirement that real estate licensees have errors and omissions insurance. I know a number of them do. A number of the large brokerages do in particular. I think in looking at the recovery account, it is in some ways like an insurance account, but in others it's not. They're very strict statutory requirements. It's a fund of last resort. Insurance oftentimes is what you go to whenever there's a problem. This is a fund of last resort. It requires that there be a judgment for intentional fraud against a licensee who performed license acts, that there be some kind of criminal restitution order, that there is conversion of trust funds. And so in that way, it's unlike an insurance policy. And then with regard to its solvency, in the 1980s, there was a problem with insolvency. And what the legislature did is you gave the commissioner the ability to increase fees on renewals, to pull monies from the real estate fund if there's ever such a problem. And so the way it's structured right now, it's sort of interesting. I've looked at all the code sections before this hearing. It has to have a minimum of $200,000. If it looks like it's going below $200,000 at the end of a fiscal year, that's when fees can be raised on certain renewals, or monies can be pulled from the real estate fund. On the top end, if it has more than $3.5 million at the end of a fiscal year, monies have to go into the real estate fund. But monies can go back and forth into that fund in order to pay the claims. And so we will have enough money to pay the claims this year, as we have each and every year going back to the 80s.
okay, very good. Thank you very much. Other questions? Seeing none, thank you, Mr. Bell.
Thank you.
I think while you're there, we will open the public comment if anyone would like to speak to the Bureau of Real Estate, and then we will move on. Good morning, Mr. Wigg.
Good morning. Thank you, Mr. Chairman, Madam Chair. I'm Stan Wigg with the California Association of Realtors. If I might, with the greatest of respect to Mr. Kanani and that breadth of issues that his department has to cover, we would like to follow up on your suggestion that we believe that the department is not well served by being a bureau within that Department of Consumer Affairs. We believe that it needed to have a home as the governor was breaking up BT&H during his reorganization. We supported the governor in his plan. We went to the Little Hoover Commission and testified that we, in conjunction with a movement that was basically an intact transplant of the department into the larger committee, we think that transplant as an experiment really hasn't worked out as well as we had hoped. We believe that it's become more rather than less expensive and more rather than less cumbersome to have our regulator in that arena. And again, it's no slur on the director, who's really worked hard to try and get this thing to work well, but we think that it's made BRE less collaborative and less nimble than it was before. And with 10% approximately of our licensees' fees going to support the DCA, we think we're not getting as good a bargain as we might have gotten had the department maintained itself as a discrete department within consumer services. I don't have the resources to cost out what the distinction would be if it was a freestanding department as opposed to an ongoing bureau, but I believe that the entities involved probably could cost that out, or at least give you a back-of-the-envelope approximation to see that if you wanted. Again, we suggest that you strongly consider moving them back into a freestanding department within the Consumer Services Agency. We would support that. We are actually the sponsors of Ms. Irwin's 1545. We're not moving that bill forward right now because we're still in discussions with the governor and his administration. Our issue with that was to try and create a Secretary of Housing at the cabinet level and have all housing agencies underneath that secretary. to be really candid, that turned out to be a bigger bite than we could chew, and so we're continuing to discuss that with the governor and his staff. That created a good bit of confusion and a good bit of pushback about the reorganization on all of the other agencies, not on BRE, but all of the other agencies that would have been involved in that new Department of Housing. And so that's why we're going slow with that, and Ms. Irwin is not advancing that bill right now. So if I could speak to a couple of individual questions that you raised in your background papers. Mr. Mendoza's paper in particular was very succinct, asking about, is it adequately funded? We think that it is. We are at the statutory cap on license fees, but they're running effectively under that cap. They're administering their operation well, and unless the loans were unexpectedly paid back, they wouldn't encounter any excess reserves. We think that they're fiscally healthy. Frankly, we opposed the loan from the department, and indeed we went back in and tweaked the statute that prohibits transfers to the general fund to include loans after the loan happened. But that was after the horse had left the corral, and indeed we can't bind a subsequent legislature anyway. You could always change the statute along with a budget transfer if you really wanted to. But we think it's inappropriate for the licensees to subsidize the general fund. That is, in effect, a double payment by licensees. Similarly, we are troubled by the notion that we are subsidizing other agencies within DCA through the pro rata fund. That's one reason why we think we're not getting maybe as effective a tracking and representation of the consumers as we might. So we would suggest that we are working with a solvent regulator. To the Commissioner's credit, his agency has been very collaborative rather than punitive. We have had good relations as a trade association, and members of the public, we believe, are well served when they complain to the department about one of my members hear about it. And I'll just leave that as it is, but for sure, the Commissioner gets the word from members of the public. We don't think you need a separate advisory group. We think that he and his staff are out there enough. They're getting face-to-face contact with my members and with the public, and we don't think you really need to formalize that with a recreation of a separate advisory commission. As to technological literacy, there was good discussion about trying to create an umbrella IT section over in DCA, but BRE has worked well with their e-licensing. We get nothing but positive comments back from our members on e-licensing and on the new electronic exams. We get nothing but positive comments back on that. Every time that we have a meeting that considers that, my members like it. They particularly like it for the ability of a salesperson applicant to, quote, stack their background check and their application so that when they actually go through their community college courses, get ready to take the exam, they can go into the exam, take an electronic exam, and walk out with a real estate sales license number. They can actually go into business that afternoon. We think that's a wonderful thing. It used to take them weeks when we were on using a paper-based system, and we wouldn't want to put that at risk at all, because oftentimes people are transitioning out of another career when they come into real estate, and that's been very valuable for us to have people go through that quickly and effectively through that process. It gets nothing but positive reviews. In terms of due process issues, that issue that the Commissioner just discussed about waiting for the appeal period to run, so long as the person's due process is protected, if the case blows up later on and it's withdrawn, we don't have a problem with going forward with that. We think that makes sense. Frankly, we kind of thought he could do that anyway, but because if he sees a danger to the public, he's still empowered to bar somebody or to suspend somebody. In terms of one of the committee analyses suggested reporting for arrests. Frankly, we think that's overkill. It's already required to report prosecutions. It's already required to report verdicts against the licensee. I would suggest respectfully that if somebody gets arrested, the last thing they're thinking about after they get out of the DUI holding is whether or not they should call their regulator and tell them, hey, I got arrested. If they get prosecuted, different story. If they have something related, different story. If they get a judgment against them, different story. And that's already covered, we think, in existing law. And then finally, I wanted to just emphasize again that we have a collaborative relationship with the department. We have several bills, in addition to Ms. Irwin's 1545, that we are working with you, and we anticipate working with your respective committees. 685 by Ms. Irwin also is a substantial cleanup. That bill has already moved to its second house, but we're going to be bringing you more amendments that basically regularize some of the definitional statutes. We make some of the, for example, some of the publications use the same terminology in both places, those kinds of things. AB 1650 Frazier is a bill that will try and regularize the advertising requirements. We have about 4 different ways that rules apply to advertising. We've been collaborating with the department on a technical basis to try and make them all read the same. Basically, we want to make sure that when somebody advertises and holds himself out to the public as performing real estate services, they know how to find them, they know who they are. AB 1750 Dodd is a bill that will apply the same definitions that apply to half of the 2079 agency law to the full section of that. Basically, it means we can use the consumer publications and inspire those to be used by everybody who works under color of a license. And finally, Mr. Ridley Thomas's AB 2330 is a bill that we're sponsoring, which will require BRE to track so-called associate licensees. Those are brokers, but who act as a sales agent underneath another responsible broker. Right now, there's a little glitch in the way they're tracked in the system. We want to make sure that they are trackable back to their boss. So if they're acting as a salesperson, even though they could act on their own, we want them to be tracked and tracked underneath the responsible broker. Again, it seems like kind of penny ante nuts and bolts stuff, but it's important to us out in the field, and it's important to consumers to know who to complain to. And so, again, we've found the department collaborative. We've found their expertise to be reliable on these kinds of technical things, and we look forward to working with you and with the department. Thank you.
Great. Thank you, Mr. Wade. Appreciate it. Any other comments from the public? Please come forward, sir. And if there's anyone else who would like to comment, come forward as well.